DWI with child passenger. What is it? Is it a misdemeanor? Is it a felony? Is there a way to defend the case? Hi, I'm Jeff Hampton with the Hampton Law Firm, and I want to welcome you to our YouTube channel. Today, I want to break down the ins and outs of the crime of DWI with child passenger. And I want to welcome you to stay around to the end of this video, because at the end of this video, I'll give you a free ebook, The Ultimate Guide to DWI Defense in Texas. Okay, now listen, first thing I want you to know is this. If you've been arrested for DWI with a child passenger in Texas, the number one thing you need to do, there's two main things you need to do. Number one, you need to contact an experienced and aggressive DWI attorney to explain and go over specifically. Now, I'm going to go over a lot of DWI law for this offense here today, but you need to go over with specifically with your criminal facts in mind, or with your family member situation in mind, so that you can get some counsel. But number two, you need to make sure and make a request for an administrative license revocation hearing, and you need to do so within 15 days of the date of the arrest. Because anytime you look at a DWI case, the best DWI attorneys break down the law based upon, number one, the license hearing, number two, the actual criminal DWI case itself. And when it comes to the license aspect, it's actually in an administrative court, it's a civil court, and you have deadlines. You must make that request within 15 days or your license will automatically be suspended 40 days after the date of your arrest. Okay, now what is the definition of DWI with child passenger? Under Texas Penal Code section 49.045, a person commits the felony offense of driving while intoxicated with passenger if the person is intoxicated while operating a motor vehicle in a public place and the vehicle being operated by the person is occupied by a passenger who is younger than 15 years of age. Now, okay, so it's essentially DWI plus a child in the car. That's essentially what it is, okay? That's what the law states. Now, under Texas Penal Code, section 49.012, intoxicated, what does that mean? Intoxicated means not having the normal use of your mental or physical faculties by reason of the introduction of alcohol, drugs, dangerous drugs, or a combination of those substances, or having an alcohol concentration of 0.08 or higher at the time of driving. Okay. Now, what does operating mean? What does it mean? Some people call it driving while intoxicated. Technically, it should be called operating on a vehicle while intoxicated. Operating means the state of Texas must prove beyond a reasonable doubt that you were doing something to effectuate the operation of this car. Okay, the vehicle must be operating in some regard. Now, the Texas Court of Criminal Appeals has expanded the meaning of operating to be much more than it used to be. Okay, for example, there have been court rulings establishing that a vehicle in drive, not even in, let's say you're not moving, but you are in a position of drive in your drivetrain there, right? You could move forward, but not moving, even though you're not moving, that can still constitute operating a vehicle under Texas law. There have also been some limited examples of courts approving the definition of operating to a vehicle sitting in park while running, and crazy examples of this. Someone sleeping it off, right? Is someone sleeping off their alcohol consumption in a vehicle with the air conditioner running? Is that DWI? Is that really operating a vehicle? These are some points we're going to get into here in a minute, okay? Now, what is a public place under Texas DWI law? Well, public place is specifically defined under the Penal Code as any place to which the public or a substantial group of the public has access and includes but is not limited to streets, highways, and the common areas of schools, hospitals, apartment buildings, office buildings, and shops. In other words, if you are in a place where the public has access to it, there is a very good chance it will be deemed a public place under Texas DWI law, okay? Now, I'm not going to get into a whole lot here related to the administrative license revocation hearing, but there are a couple of things that they're looking for if you have an administrative license revocation hearing. Number one, you cannot miss that 15-day request to make sure and be able to preserve your right to that hearing. But under Texas law, there is something called an implied consent law. And most people don't know anything about this. But when you agreed to get a Texas driver's license, there is an assumption and an implied consent that you made that if you are pulled over or investigated for driving while intoxicated, you will have impliedly consented to give a sample of your breath or blood to a police officer. So as a result of that, if the officer had reasonable suspicion to pull you over and probable cause to arrest you, and then you refuse to give a breath or blood sample, he can actually suspend your license for up to 180 days. Or if you consent and you are over the legal limit, he can actually suspend your license, or the court can suspend your license for 90 days, okay? That's the rules related to a license revocation hearing, okay? Now, there's some areas, though, that your attorney should look into. For instance, if that police officer did not have reasonable suspicion to pull you over, okay, or probable cause to arrest you, that can be a reason for which you can win in your license revocation hearing. It also could be a reason why you can win your DWI child passenger case as well. The police must have more than a mere hunch as a reason to pull you over. There should be some type of traffic violation, something that gives them a legal basis to pull you over. What if the police didn't read you your statutory warning form? What if they never actually gave you a chance to consent or refuse? If they didn't actually read to you what's called the DIC-24 statutory warning form, that is another reason for you to potentially be able to win your license, your administrative license revocation hearing, okay? Now, here's another reason. What if you consented to everything and your blood alcohol level was under 0.08? Well, in that situation, your attorney needs to make the request and you will win at your hearing. Okay. Now, what is the penalty for DWI with a child passenger in Texas? Under Texas Penal Code, section 49.04, it is a state jail felony offense, which imposes a fine of up to $10,000 and a prison sentence of not less than 180 days, but not more than 2 years. It also can result in a mandatory driver's license suspension. And if you receive a probation for a DWI with child passenger, you could be looking at a DWI term. You could be looking at up to a 5-year term. You could have intensive conditions, classes, treatment that you might have to get involved in. And unlike a felony DWI, you don't have to have any previous criminal history. By there merely being a child in the car, it doesn't matter if you have a clean record, it is still treated as a felony offense. A regular felony DWI requires you to have 2 prior misdemeanor DWI convictions before it becomes a felony. But that's not the case when you're talking about a DWI with a child passenger, okay? So that is where it's sometimes the most unfair. We represent a lot of really good people, a lot of great folks, never been in trouble their whole life. They go out and they get a drink at a restaurant or a bar. They get pulled over for a traffic violation. Police officer smells a little bit of alcohol in their breath, and now all of a sudden the district attorney wants to make them a convicted felon. Now all of a sudden they stand to lose their job and their future and maybe even their freedom. That's unacceptable. We want to do the best we can to make sure and provide that defense. And that's why it's important that you understand what the law says. Now let's talk for a few moments about legal defenses. And I'm going to reframe some of the things I said earlier, but some of the legal defenses to DWI with a child passenger in Texas. Number one, can the state of Texas actually prove that you were operating a motor vehicle? So were you parked at the time that the police approached you, and were you in your vehicle parked? Maybe did they attempt to interrogate you regarding the driving the vehicle and you remained silent? Maybe you didn't talk about who was driving or not. The state of Texas, through the district attorney's office, must prove beyond a reasonable doubt that you were operating that motor vehicle in order to convict you. For example, we have represented, kind of what I talked about earlier, we've represented clients that were asleep in their car during the summer. They kept the car running and in park, and in order to use their air conditioning, they kept it running so that they could, be cool while they sleep, right? They never once drove the vehicle while intoxicated, but then you have a police officer arresting them for the crime of DWI. If you did not admit to having driven the vehicle at all, your DWI lawyer can make a very persuasive argument to the jury. And look, we've done this. The reality of it is this: the jury needs to understand you are doing the responsible thing. When we have a client that's doing the responsible thing by sleeping it off, not driving that vehicle at all, and the only thing they're doing is sitting in there asleep, there have been juries that have had a problem with that in factually determining that the individual was operating that motor vehicle, okay? So there is an argument there that is not fair to convict, and it's also an argument that it's not operating from the jury's perspective. Now, what about the fact you were not intoxicated at the time of driving? That's defense number 2. You were not actually intoxicated at the time of driving. What if a DWI officer took a breath sample from you or a blood sample and it came back as over 0.08? Does that automatically mean you are guilty of DWI? Does it automatically mean that you were intoxicated? Not necessarily. Remember, what time did it take? What was the time frame from when you were driving or operating the vehicle to when they took the blood or breath test? If it was multiple hours later, all that shows, that blood test only shows what your blood alcohol level was at the time you gave the test, not at the time you were operating the motor vehicle. So we have seen routinely many situations where a blood test wasn't taken for 3 or 4 hours after the individual was operating the motor vehicle. They must prove your intoxication at the time of operating the vehicle. So what they try to do is extrapolate back in time. They want to ask you a list of questions. What was your last drink? How much did you have to drink? What did you have to eat? They want to see if they can gather enough evidence from the accused to be able to put together something where a toxicologist can get on the witness stand and establish that someone is intoxicated, okay? So just because a blood alcohol level is over the legal limit does not necessarily mean there is sufficient proof beyond a reasonable doubt that someone was in fact intoxicated at the time of driving. Finally, the last thing I want to cover, and I'm not going to spend much time on this, is your attorney needs to break down whether or not this traffic stop, if you were pulled over for a petty traffic violation, it's important to make sure that it's actually legitimate and legal. I'm going to give you an example of that. We represented a pilot one time who had been arrested for a DWI, and the officer claimed that one of his front headlights was not operating properly. And so we were just left with taking the officer's word. But upon reviewing the video and looking at it very intently, it appeared to us that there was, in fact, a light that was operating just fine. It looked like there was light coming directly through the bulb itself. And as a result of that, even though he was over the legal limit at the time he was operating that vehicle, it would not have mattered because the traffic stop itself was illegal. In fact, the jury rendered a not guilty verdict based upon an illegal traffic stop. So it's very important. Don't just assume what the officer says is correct. It's important to not only dissect the police report, but to go into that video and look at it intently to see if that legal defense may apply to you. Okay? Now listen, these are just a few of the things to consider with a DWI with child passenger case. As we've talked about here, this is a serious crime. It's a felony. And you want to do all that you can to avoid a felony conviction if possible. If you are facing a DWI child passenger case in the North Texas area, I want to invite you to contact the Hampton law firm. You see the number that's right above here on the screen. Contact our office. We'll be happy to give you a free case analysis and a consultation and see if we can be of assistance to you. And listen, I promised you a free ebook. If you waited around to the end of this video, I want to give you the ultimate guide to DWI defense in Texas. If you'll click the link down below, I'll be happy to send that over to you. And I want to thank you for joining us here today. If you've enjoyed what you've heard, if it's been helpful, subscribe to our YouTube channel, like our video. We'll send you more Texas criminal law content like we've done today. All right, thanks for joining us. We'll see you next time.